Hi, everybody. Welcome to Management 424, Chapter 14. In Chapter 14, we're going to be looking at issues surrounding the consumer as a stakeholder of business. As usual, please review the learning objectives for this week's material in Chapter 14. This week, we're going to be looking at the major rights of consumers. We're going to be analyzing the reasons for consumer advocacy and the methods consumer organizations use to advance those interests. We're going to be assessing the ways in which government regulatory agencies protect consumers and what kind of products are most likely to be regulated. We're going to determine how consumer privacy online can best be protected. We're going to look at how courts protect consumers and efforts by business to challenge those protections, product liability laws. And we're going to evaluate how socially responsible corporations can proactively respond to consumer needs. Historically, the rule of caveat emptor, or let the buyer beware, applied to consumer rights. Essentially, that meant you buy the product, you take all the risks that come with it. As time has gone by, consumers have obtained a number of rights insofar as their interaction with business is concerned. Those rights include the right to be informed about products and risks, the right to safety. Products shouldn't kill us, but what about things like guns, alcohol, and the like? We should have the right to choose. We should have the right to be heard. We should be able to have any complaints we have expeditiously and fairly heard. And we should have a right to privacy, which is more important than ever today. Really beginning in the 1960s and 1970s, this is when we saw the birth of the consumer advocacy movement in this country. Our consumer protection framework in this country consists of these four areas: self-action by consumers, lawsuits, things of that nature, government regulation, business self-regulation, and again, a socially responsible corporation should be producing products that don't harm the consumers, and then the courts, which sort of, I guess, tie in a little bit with consumer protection in that they're consumer self-protection and that it's the consumer that's filing the lawsuits. Consumerism and consumer protection have come about for a number of different reasons. First, products are much more complex today than in the past, making information about those products critical and more important. Second, services and products have become more specialized and difficult to judge. Third, advertising, you might find this hard to believe, might be misleading. Fourth, technology has put our privacy at ongoing risk. And lastly, some businesses simply ignore safety for costs and other reasons. The government, through food and product regulations and the like, has made an effort to protect us. We have seen, however, though, an ongoing trend towards deregulation and almost a move back to caveat emptor. Let's hope that we don't go that far with deregulation. Slide 8 contains a small print, albeit a complete, summary of how the government attempts to protect the consumer through regulation. Spend a little bit of time looking at this slide and you can see that virtually every product and service that is produced by business in this country has some form of a regulation or two attached to it. While consumer laws cannot totally protect us, they try to do so. What they try to do is provide the consumers with information when making purchases. They try to protect consumers against possible product hazards. They promote competitive pricing, and hopefully they promote consumer choice and protect our privacy. Because of our own actions and the collection of data, our data by business, we are at an ongoing risk of having our privacy and personal information compromised. Behavioral advertising allows advertisers to follow us around on the internet. I have a son that works for Google, and when I asked him what exactly he does, he apparently is involved in writing the code that allows that to happen. So behavioral advertising is that advertising that's targeted to particular consumers based upon online behavior. So think of the last time that you went to Amazon or any site and looked up a turntable or a car or something like that. Isn't it interesting that coincidentally, every ad that you seem to see thereafter, wherever site you're on, happens to be for that particular product or one just like it. How can our privacy be protected online in the consumer age? Can it be totally? Well, there's consumer self-help. Perhaps we should not put so much out there. A lot of the stuff that we put out online, be it through Facebook or Instagram or the myriad of other online interactions that we have, we're the ones responsible for putting that information out there. So maybe we shouldn't be quite as free with our information. Maybe we ought to start using more VPNs or virtual private networks. Perhaps we shouldn't do things like conduct our banking business in hotel lobbies and the thing like that. So what we do, we can play a big role in doing some basic things that protect our privacy. There should also be proactive industry self-regulation where business, because again, they know what happens when our privacy is compromised and the massive PR hits they can take, they need to do self-regulation to prevent these breaches from occurring. And then privacy legislation, the governmental action to protect our privacy. The courts have historically, at least since about the 1900s, been a pretty potent tool to protect consumers. There's been a series of laws and cases that have developed that we sort of know as products liability law or tort law. And in that body of law, generally we have consumers or people who've been harmed by products sue manufacturers for injuries caused by those products. Courts and through large judgments can hold business accountable for its behavior, and through the implementation and imposition of punitive damages can hold businesses responsible by sending a message not only to that business but other businesses in the same industry that kind of behavior is not going to be tolerated. There's been a pushback to that, however, and we've seen a pretty aggressive set of tort reform laws being proposed both at the federal and the state level. And this has been a response and a pushback attempt to limit the rights of injured consumers to sue for such damages through efforts to limit damages and the like. There's also a type of product liability law called strict liability. And in strict liability, this is where a manufacturer is liable for injuries, whether those injuries were caused through their negligence or not, due to the nature of their products. So there are certain products that are just inherently dangerous, and think of things like explosive devices, hazardous waste transportation, certain medical products. The courts have basically said there, the fact that you have chosen to manufacture or engage in this business, if something bad happens, you're going to be held responsible whether it's your fault or not. And so be very, very careful. Many seeking to limit court-imposed liability against business have looked overseas for a solution. One of the things that they've attempted to do is limit punitive damages. These punitive damages are the damages that you'll see in a lawsuit where somebody will be awarded $10,000 for their actual damages, their out-of-cost medical expenses and things like that. Yet because the conduct of the company was so egregious, there might be a $50 million punitive damage, which isn't necessarily tied to the injuries, but again, it's there to send a message. So in many cases overseas, we see the inability to collect those punitive damages. We've also seen other countries adopt what are known as the loser pay system. And in a loser pay system, the loser of the lawsuit is required to pay the costs of the winner. And this is designed to discourage frivolous lawsuits. So for those of you who stay up late at night and see all the lawyer ads on TV where the lawyer says, hey, it'll cost you nothing unless you win, under the frivolous lawsuits and loser pay situation, it would cost you something if you didn't win. So that's designed to discourage these people who are out there looking to get rich quick. Another effort that has been attempted is through businesses attempting to get consumers out of the court system and put them into alternative dispute resolution situations like mediation and arbitration. And basically, if you have any credit cards, if you buy cars, if you've done any consumer business lately and you've read the fine print in your agreement, you will see that in many cases you are agreeing to have any dispute about the contract, the product, what have you, decided in arbitration as opposed to mediation, or arbitration as opposed to litigation. And again, this allows the corporation or the business or the wrongdoer to avoid things like punitive damages and things of that nature. There's a couple of different kinds of alternative dispute resolution. One is mediation, and mediation we don't see used as much in consumer or this kind of area of the law, where a third party tries to bring the parties together on a resolution or dispute. We see this in family court quite a bit, where a third party tries to bring the husband and the wife together on a resolution of their case. Then there's arbitration, and in arbitration, that's where a third party neutral will hear and actually decide the case. Depending upon the agreement, that decision can be binding, which means that you're stuck with it, or non-binding. Socially responsible entities have attempted through quality management to design and manufacture the product to minimize potential harms. Again, one would hope that a socially responsible corporation is not cutting corners and putting dangerous products out there. Some industries have created voluntary codes of conduct to ensure the proper manufacture of products and how customers will be treated. Large entities would have a difficult time, in today's world anyway, functioning without a consumer affairs department. These consumer affairs departments are designed to run interference between the company and those customers and other stakeholders who might be having issues with the products or the services. Products that are found to be defective or dangerous are subject to product recalls. Generally, if a company finds itself with a product in this category, it's usually best to do a voluntary product recall as opposed to having the government impose one on you. Think about the Tylenol case from back in the 80s, where we had adulterated Tylenol, and Johnson & Johnson voluntarily pulled every bottle off the shelves. They were able to recover from that crisis relatively quickly. Compare that to the Firestone and Ford Firestone situation, where neither of those companies took any sort of responsibility, and there was an involuntary recall, and basically they're still reeling from that to some degree today. All in all, the consumer movement has resulted in better informed consumers, safer products, and more and reliable ways to resolve disputes. So that's our discussion on Chapter 14. We will visit with you again next week when we move on to Chapter 15 and 16. So we'll see you then. Thanks.